If you may please, Honorable Court, my name is Mpofu. I still appear for the state.
If you please, Honorable Court, my name is Jake.
My name is Elma Dukua. I appear for the second accused. My little friends are not in attendance. My Lord and learned assessors, I am on my feet to seek an indulgence from the court. That indulgence said this matter had been set down for today and Monday 17. Seeking this indulgence is that on the side of the defense, we are not fully present. We do not have 3 of our colleagues here. I'm saying so, my Lord and learned assessors, I'm speaking on behalf of the bar for the defense, and we thought we could make the application as a collective. We have had the unfortunate situation where our colleagues then got to be engaged in other matters way beyond their control. 2 of them are not in Harare, that is Mr. Jetero and Mr. Mukia. We certainly need our entire team to make preparations. We are of the respective view that the sentencing stage is a very critical stage in the process. And that the accused persons are not responsible for the state. He had indicated that he would not be opposed unless he has changed from the last time I spoke with him.
Yes.
That would be my submission at this stage.
Mr. Mabodi. Thank you, my Lord. Honorable assessors, the state during the last sitting had given notice to the court and my learned colleagues that the state intended to make an application in terms of section 50 subsection 1 is read with section 39 subsection 4 of the Money Laundering and Proceeds of Crime Act, Chapter 9.24. On further reflection, my Lord, the Prosecutor General has decided not to make the application during these proceedings that are ongoing, in that the trial has reached a critical stage that the accused person have to undergo a victim assessment, impact assessment in terms of sentencing guidelines as shown in SI 146 of 2023. As a result, the Prosecutor General decided to withdraw the notice of filing that application, which has been uploaded onto the system, and I'm quite sure my learned colleagues are aware. The court application in terms of the Money Laundering Act will be made by the Prosecutor General separately to allow this court to proceed to trial. And therefore, as a result, the state is ready to proceed to issues pertaining to pre-sentencing procedures. And therefore, as a result of the withdrawal of that notice, the state is no longer in a hurry to request for a written judgment earliest convenient time. And it is the state would also like to put on record that it is also, in terms of sentencing guidelines, it is also filed its address in that regard. And now awaits the response from my learned colleagues before it motivates its written address to the court. In respect of the application that has been made by my learned colleague, Mr. Maduku, my Lord and Honorable Assessors, it is said that this date was by consent. All the parties were in attendance, and there hasn't been any excuse by my learned colleagues who are absent, indicating that they are engaged in engagements to the present application for the postponement. I'm sure, my Lord Honorable Assessors, I think the court needs to, in attendance. This date was by consent. And therefore their absence, my Lord, they're inconveniencing the accused persons and the state and everyone else. And therefore the court has to show its disapproval towards that kind of behavior that has been exhibited. Because my learned Mr. Maduku is now developing a good tendency of putting his words into the state's mouth that we were discussing and agreed. No discussion had been done. In actual fact, Mr. Maduku is supposed to apologize for arriving very late. We were all waiting for him. He was actually supposed to apologize. We were supposed to start at 11, and he had come quite late. And such discussion about the state conceding to his application had not been done. But however, in the interest of justice, the state is not going to oppose the application, because justice must be seen to be done to the accused persons. That is what my Lord and Honorable Assessors.
Those things can be said when we meet next, and I can say in seeking the indulgence of the court to accept the...
No, you don't wish to favor the court with information regarding their whereabouts? And view that the fact that the matter was postponed to this date by consent. Anyway, I will not pursue that. Maybe I just want us to be clear. We are postponing the matter to Monday for the pre-sentencing inquiry.
Indeed, my Lord. The problem that we face is that my learned friend has said, for as far as the state is concerned, they are not... they no longer need the judgment of the court to be available first. On our side, when we meet for the pre-sentencing, we would certainly raise that issue. But it's a matter that can be determined or resolved before we appear in open court on the date of the postponement. But I can confirm that on the side of the accused persons, they would require the judgment, the written judgment, to be available for that process.
It's not available. I mean, you have seen that it has not been uploaded, which means that my understanding really was that when we convened for the pre-sentence inquiry, the state then indicated that an application was going to be made following the conviction, and before sentence could be, before we could proceed with the pre-sentence inquiry, So that is what then resulted in a request, for the reasons for the verdict. It's not the usual way, but because the state had intended to embed the application in this criminal proceeding, we had acceded to that request. But in view of the indication by the state that they are no longer pursuing that, I don't think there would be any legal basis for the accused persons to say we require that judgment, the written judgment, because I remember quite well when before reading the judgment I said all parties must make extensive notes for the purposes of dealing whatever further proceedings, if any, that may arise after the judgment. So I could see that everybody was recording the salient features of the and that is the procedure intended. The request is a departure from the because the state had intended to do something else which they have abandoned. So I don't want to give the impression that I may accede to that request. I will not.
My Lord and the court, I had wanted us to deal with the postponement. It was my learned friend who has put it in this coming out. I would respectively submit that it be an issue that first and foremost we resolve with the
through the usual case management procedure.
Yeah, through the usual case management procedure. Thank you, my Lord, for that language. I think it's my learned friend who has caused problems with this. Is the lengthy address to the court for the Monday process before we come to open court. That would be my submission.
The situation that we find ourselves in, it's not really appropriate that we should continue to gather people in order to deal with procedural issues. I had hoped that by now we would have taken a position, and even in the absence of physical presence by your colleague, I encourage you to discuss this issue. We really need to be sure of what is going to happen on Monday. Mm-hmm. It's not right that we should gather all these people, gather the press, bring the accused persons to court for us to be discussing on the way forward. We should be able to do that, as I said, through case management and come to court to deal with the real issues. I should stand down this matter, and so that we finalize that issue. I don't want to leave that hanging until Monday, and then we have another discussion. No. Unless you have any other submissions, but I want this issue resolved before we defer the matter.
Yeah, we had wanted, my Lord, if you are with us, you could certainly grant the postponement. We undertake to ensure that we resolve it before Monday, so that we don't have to come back and sit. We would be able to deal with it as officers of the court. We should be able. What we can undertake is before we meet on Monday, we would have had.
No, I hear you, Mr. Maduku, but that is the opportunity I gave to the parties yesterday. And I had actually hoped that the matter would be resolved before today. That was the indication I made. But then I see that it still has not been resolved. There's a real possibility that you may not reach agreement, which means that we will convene again on Monday without agreement. I don't see why you cannot get in contact with your colleagues and that we have all known as the procedure. And so I want to be sure that on Monday we are convening for what purpose. So I maintain that we should stand on this matter so that you can liaise with your colleagues wherever they are and we finalize the issue. If you want to come to my chambers for case management, I'm available. I don't know what time it is now. Yes, I'm still available up to 2 p.m. That is when I'm supposed to be preparing for another case. So I'll be waiting in chambers.
As the court pleases.